Hello and welcome back, everyone, to Immigration Talk Show. I'm Napasa and I'm going to be your host for this session. Thank you so much for joining us here once again. And friends, this is Immigration Talk Show. We have a very interesting webinar lined up. And before we have our guest for today's discussion, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, welcome once again to this very important session, I would say, because it's going to be on a very interesting topic, what we are all wondering and reading a lot about, especially because it's the season. So, what is the impact of new H-1B regulations and FDNS site visits? And of course, we are going to also discuss about the April 2025 visa bulletin, which is already out. So it came out yesterday, and we are going to discuss some highlights with our guest. So, yes, let me introduce you to none other than Uma Mantravadi. How are you doing, Uma? Thank you so much for joining us. How are you? So,
I'm doing great, Napasa. It's such a pleasure to see you again and to have this session with you.
Same here, Uma. It's exciting. I think this year we didn't meet, I mean, like this for a discussion. So I'm really happy to be here. And folks out there, for those of you who I'm sure are wondering who is this familiar face, let me tell you that she is none other than attorney Uma Mantravadi from Mantra Law Office, which is a highly reputed firm, and it's located in Houston, Texas. So United States, at around this area, Mantra Law Office is where it's going to be also very busy. So yes, Uma has expertise and experience for over 3 decades now. So I'm sure, friends, you must know her or want to know her for sure. So go check out www.mantralaw.com. And yes, thank you, Uma, once again. So
My
um,
pleasure, Nipasa. So much going on under the Trump administration, as you know that, and there's every hour by the hour we get information that is updates and can be surprising to our listeners. I mean, there's people even ask me this question: how are you able to digest this information? By the hour it comes out, and then the changes. There's so much that's going on, and in fact, me and Sam had talked about a couple of weeks ago that the forms were retracted back to an old edition, which caused a lot of problems for attorneys where the forms were being not accepted and the packages were sent back by many attorneys, especially the 485s, many other forms. So, as a group of attorneys, we have filed a lawsuit against the government, and now they are
okay.
accepting all additions and will give us additional time to let us know what addition they will accept in the future.
Very
So I
interesting.
guess
So,
it's going to be a game of lawsuits, going back and forth.
how's the response so far? Are they reacting well to this?
A good question, Nipasa. I wish I could say there's anything good, but
Mm.
we always take the positive side of everything. There's always a negative side, but there's always a positive side. And, that's what we bring to this show to the listeners to ease their lives, to kind of give them a path, a guidance, hoping that they would go on the right path. So,
Absolutely. Thank you so much, Uma, and it's always a pleasure to have you. So, as we start today's discussion, also, you said you have a couple of updates. So, would you like
yes,
to give them first?
yeah, that lawsuit was one of the updates that I wanted to bring about. And then, second thing, the Department of State, they've eliminated what's known as the deference policy on non immigrant visa waivers. What that means is, a deference is kind of going to your history and giving weight on your history and your documentation. For example, if somebody had an H1 and had an H1 approval, they would give deference to that approval from the past, not just the current one. And that would give some benefit to the applicant filing an application. And but this one particularly, they're talking about removing the policy from consular officers recommendation of approval of non-immigrant visa waivers. They're talking about waivers. Like, for example, if somebody had an individual waiver for a non-immigrant visa due to any ineligibility for in or called as inadmissibility due to medical grounds, criminal grounds, immigration violations, fraud, misrepresentation, any of these grounds, if somebody has been denied a visa and they applied for a waiver, now they could use that waiver that was obtained in the past, even for the current situations, and move on. That's what was the deference policy. But now the department is saying, that Department of State is saying, we don't have to go with your deference of the non-immigrant visa waiver. We can definitely request you to get another waiver before we can grant you the current visa. It can be an H1, an L1, or a B2, doesn't matter. Just because you got the waiver in the past, we're not going to give deference to that. We're going to ask you to get another waiver so that, we want to make sure you've not violated anything in between. So this is going to place additional burdens on people who've had violations and then who've got a grant of the waiver now have to go back and get a second waiver, so they have to review each waiver application independently, and a new waiver has to be approved before the officer can give any undue deference or rely solely on the previous officer's decision to grant that waiver for the approval. So this is going to put additional work on people, additional delays on cases. So it's not great news, but that's what it is.
Well, thank you so much, Uma, for that very important update. And folks, yes, thank you so much for joining us. Rahul, thank you for your questions. Please stay with us. We are going to address them a little later in this episode. So, yes, and Uma also, the visa bulletin is out for April
Yes.
2025. Yeah, so let's look at some of the key updates and changes, maybe. What do you say? So,
EB1 for India has advanced to Feb 2020, Feb 15th, 2022. EB2 category has moved to Jan 2013, and EB3 for India has progressed to April 2013, April 1st. It's a little bit of an improvement. I wouldn't say it's extraordinary, but I think, even if it is moving at a snail pace, I think people from India are still happy to see some improvement in
improvement,
the feasibility.
right?
So we can
Well,
talk more about it, but those are the cutoff dates. And EB3 other workers is also at April 1st, 2013 for India.
mhm, mhm. Right, right. So, thank you, friends. There is little movement, of course. There are also retrogression that you can see, but it's not that great, like Uma has mentioned. It's not extraordinary or wow that we can talk much about it. We'll just have to be patient. But congratulations for folks whose dates have finally come, and all the best for the rest of, the process. And
Right.
yes, Uma. So coming back to some of our questions, our topic of
I know you
discussion.
mentioned
Yeah.
about the retrogression, and I didn't talk about that, which is the EB5. EB5, India's unreserved EB5 immigrant visas numbers that are not set aside for rural or high unemployment or TEA. Cutoff date is retrogressed to November 1st, 2019.
Yeah.
That is the retrogression. And
Right.
EB5, of course, right now there's still the 800,000 for the rural as well as urban investment for target employment projects, as well as, high unemployment areas. But if you're doing an individual investment, it's still 1,050,000. But of course, Trump has discussed about the gold card that is not yet the law. Right now, EB5 is a legislation by Congress, and so this will remain in place until September 2027. But we
Mhm.
don't know what the Trump administration still can do. As you know, that they can always bring about executive orders to create chaos.
Yeah.
Will they do that? We don't know that.
Well, we'll just have to wait and watch. But I know the gold card is also making quite a lot of noise. Just the $5 million news, I would say, and so many hopefuls out there. But let's wait and watch. We never know what's going to happen. So, also, our topic of discussion for today is about FDNS site visits. So, if Uma, you can also provide sort of an overview of the FDNS and what significance it has in the context of H-1B visa rules and requirements.
Yeah, sure. Thanks,
Thank you.
Napasa. First of all, FDNS site visits is not something new under the Trump administration. It's been there for a while, even under Clinton, even under the Obamas, George Bush, all of the presidents, pretty much we've seen it. But I think the enforcement is going to be much stronger under the Trump administration's second term, because immigration has been the discussion and focus for President Trump under the second term. And, as you can see, deportations are on the high priorities, and this has been going on. So, what is FDNS? FDNS is the short form of the Fraud Detection and National Security Directorate, which is a division of the US CIS, which conducts, let me use the word clearly, unannounced site visits, particularly to H-1B employers, as a part of the compliance and fraud prevention efforts. And this visit is the aim is to verify the legitimacy of an H-1B petition and making sure that an employer and employee are both adhering to the program requirements, And because of the recent changes, as you know, the H-1B modernization has come about in 2025. These visits will affect both employers and employees because of this. And it is widely expected that the US CIS will increasingly shift its focus towards enforcement efforts, more under this second term of the Trump administration. And that's why the employers should be very familiar with what or how these FDNS site visits are conducted, and how can one be prepared with these visits in advance. So that's what I wanted to talk about. Just to give, I can't tell word to word what the FDNS officers can really mention, but we can what are the things that they possibly can ask, So that's what I'm talking about.
Yes, that's right. And they are surprises, like Uma has already said that they are unannounced. So it can happen anytime. All we can do is play safe. So abide by the rules that you have to follow. The of course, company policy, and goes without saying that your workspace has to be your workspace, and you should be working while it's your time to work, right, Uma?
Absolutely. Well,
And document.
go ahead.
No, and what about a document? Should like suppose there is a visit, and what will they be asked for? Of course, their identity card, probably.
Let me go through possible scenarios where, there's typically an unannounced USCIS officer visiting the work location specified in the H-1B petition. And if they give a third party site, they're going to go there. If they give their own office location, they can go there. Or if they are giving the location of a remote, for example, if the employee is working from his or her own apartment or home, they can go there also for a site visit. And when they do go, they typically engage in one or more of the following things. They verify the physical existence of the business. For example, if the employer has given their office address, they can go there to verify if they really exist or they don't. Confirm the employment of the employees designated work site. They want to make sure, if they're, like I just said earlier, if it's at a third party location, interview the H-1B employer or employee or their representatives. They can review the payroll records, timesheets, work schedules, any other connected documentation, and they can probably assess the compliance with the H-1B regulations. So basically, the idea is to prevent fraud or misrepresentation by the employer and the employee.
Well, well, right, very rightly put, and thank you so much, Uma. So these were some of the documents that or questions that you could be asked for. So Uma, thank you for highlighting them. And also at this moment, I'll quickly say hello to Yash and Echo Alex. And I think let's take Echo Alex's question. So he's asking for El Salvador TPS extension. Do I need to fill out Form I-765 and pay the fee, or just I-821 form?
If you need the work permit, definitely you need to fill up the 765 and pay the fees accordingly. There is a whole chart of fees that you need to make sure you're paying the correct fee.
All right.
This is for TPS, which is also known as temporary protective status.
Right. Right. So all the best to Eco Alex. And now let's also quickly address Yasha's question. I've heard that FDNS site visits are becoming more common. Do you How do they decide who to inspect? And are certain industries, companies, or job roles more likely to get a site visit?
Not really. They don't go by industry or they don't go by employer. It can be a Microsoft or it can be a mom and pop kind of small employer with only 2 people or 10 people or 100 people. So it all depends on the officer. If they feel there is a red flag somewhere, the documentation was not clear, or they feel there is some kind of a fraud, in their own mind, how do they determine they're not going to tell anyone about that? Or if they get a tip from somebody, it can be any of the following reasons that can lead them to an FDNS site visit. So we cannot say it's because of a job duty, job role. It can be for any umpty number of reasons.
So it's just like the lottery then. How lucky your day is today. Anyway,
Exactly.
but thank you so much, Uma. And thank you, Yash, for participating. Thank you for your question. Very interesting. And also, let's take up Rahul's question. I am an H-1B visa holder working at a third-party client site. With these new regulations, is there a higher risk of denial or site visits? And what kind of documents should I keep ready in case of an FDNS inspection? So, Rahul, I hope you were watching us. We've already addressed these questions and also discussed a few, possible questions or, demand for documentation by the inspection officer. And also, maybe we can take up the first part, Uma.
I've
Third
lost
party
you with
client
the
side.
first part. Oh, he's
Yeah.
working at a third party client site. Okay. That has to be, they'll check the LCA possibly to make sure that the LCA has the third party client site listed, or if it is a hybrid work arrangement. And, they can, FDNS officers typically have a wide and great authority to assess compliance at multiple work sites. So if they don't actually come to you, they can go to the third party client to verify your employment. They necessarily don't have to come to you, the employee, to get this information. They can get it from the third party vendor to get that information. So, under the new H-1B regulations, we are definitely expecting increased scrutiny, increased FDNS site visits, verifying job duties, employee qualifications is going to be a big question too. Employees placed at third party client sites, depending on each case by case or circumstances, Nabasa, FTNS may check with end clients, like I just said, whether the end client's minimum requirements have been met with or matched with by the employer. For example, if the end client is requiring a software engineer, but then
Mhm.
you placed a software developer, so now that is a red flag.
Okay. So the job description is very important, and doing what is said in the job
It's a
description is
meeting with the job requirements of the end client.
right. Right. So thank you so much, Uma, for taking that up, and Rahul also for a very important question. So third party client site. And now, Arpita, hi, thank you so much for joining us. I wonder where you have joined us from, but thank you for your question. So let's take it up quickly, Uma. So she's asking, I've been with my employer for over 4 years on H-1B without issues. But now I'm hearing that even long term employees are being scrutinized under these new rules. So, why is that? And should I be worried?
I wouldn't say long term, short term. There is no uh, reason to say a long-term employee will not be scrutinized by a FDNS visit. FDNS are equipped with lots of additional sources to detect fraud. Nipasa, for example, they have leveraging data analytics with their USCIS office to flag any inconsistencies in employer filings, be it old, be it new. They have the data analytics to do that. The employers found to have submitted any kind of false or misleading information also will face heightened penalties. So, they have every um, information and leverage to get the information. And
Mm,
based on that, they can go with an old employer. Old employee doesn't matter. Somebody's
mhm.
been beyond the 6 years, they're filing for an extension, even that can be an FDNS visit.
Okay, okay.
So it's got nothing to do
Thank
with how long or how old, how long you've been with one employer or employer two or employer three. And as I said, there's a lot of
you.
questioning about the verification of job duties, employee qualifications, whether they meet the end client requirements, whether employer is in compliance with the LCA salary. A lot of employers I see that they don't pay as per the salary. In fact, some
Yes.
of the employers pay a month later. If they're supposed to pay the Feb wages, typically are not paid till March or till April.
Mm-hmm,
So
mm-hmm.
those can be problems too.
Right, right. So pay stubs are going to matter as well. Who knows? They would ask.
Absolutely.
Right.
Absolutely.
Thank you, Uma, for addressing this for Arpita. And folks, thank you for your questions. I would like to say that we also have a calling in line available. So why don't you call us to ask your questions? Echo Alex, Arpita, thank you for your questions. Why don't you join us on 425-436-6335, and the access code is 988-888. So if you call in, we are available and you can talk directly with none other than Attorney Uma Mantravadi. So you can also email Uma in case you want more attention on your case and you want proper guidance or probably just a one-on-one consultation. You can call her on her number 713-787-5297, or email uma@mantralaw.com, or go visit www.mantralaw.com to get to know more about Attorney Uma Mantravadi. So, Uma, also, we have more questions to address.
Sure.
Let's quickly take a couple of them. My next question to you would be, about the main changes in the new H-1B rules. How are they affecting employer responsibilities?
Well, like I said, Nipasa, the F1, H1B modernization brought about a few good changes, and there's also uh, great length of discussion about enforcement and FDNS site visit. The good changes are, for example, in the past, an employee could not be a partner or hold any kind of partnership or stock, holding stocks in that company. In the past, you could not do that. If you did that, that would be considered as a bias. But now they're saying it's okay, you can be an employee and be a part owner of the company to file the H1. So that is one good new rule that is coming about. They're also saying we're going to give deference to your previous H1B approval. So if we see that you've had prior H1 approvals, we're going to give deference to that to make sure, that you have a greater weight on your possible approval of the H1. Of course, they're still going to go through and make sure everything is in compliance, even though, they're going to give deference to the previous H1B approvals. But one of the key compliance requirements for H1B employers is maintaining also the public access files. The public access file must be readily available for inspection and contain, the certified LCA, the wage rate, explanation how the wage was determined, documentation of any previous wage sources, statement of notice to workers, meaning where did you place the LCA. All this plays a crucial role when there is a FDNS site visit, and it serves proof that the employer is complying with the wage requirements and the labor conditions. And if you don't maintain the PAF, which is a public access file, it can lead to penalties and compliance issues. And Napasa, we've seen some employers in the past, they were also banned from filing H1s if they felt the violations were extreme and the persons did not maintain the proper public access files. They even blacklisted them and did not allow them to file H1s.
Right. Right, Uma. Thank you so much for bringing that up again and highlighting them as well. So, yes, a lot of things are to be kept in mind, and there are new rules which, you would like to check out as well, it's always best to stay updated, do your research properly, especially when
Absolutely.
whichever visa that you are applying for, get to know more about it and what rules govern all that, and play safe, of course. So also, there were new rules much before even the new administration came into being. A couple of days, right? I think it was January
Yes,
17th.
this modernization rule was implemented on Jan 17th, 2025, exactly
Right,
4 days before President
Trump.
Trump took the office.
Right, right. So yeah, now coming to my next question to you, Uma, would be, how does these new rule make FDNS site visits mandatory for employers?
It doesn't make it mandatory for employers, Nipasa, but then, as I said, with the data analytics and information available to USCIS, if they feel there's a red flag going off, they can always, come to an employer to make sure they, audit your existing public access files. They can ensure the records are, kept complete. If you haven't, you need to make sure that you maintain accurate and up to date employee records, which is keeping copies of their paychecks, W 2s, in case of any FDNS visit. So, right now, as I mentioned, this Trump administration is looking for more of enforcement rather than just looking at compliances alone. Compliance and enforcement kind of come together. So definitely there's going to be more site visits, and employers should mandatorily maintain a proper public access files.
Okay, and just in case, these employers, they do not cooperate with these FDNS site visits, inspection officers maybe. So what do you think is going to happen next?
As I said, possibly penalties could be also a risk of getting blacklisted where they will not be allowed to file for any future H-1Bs.
Mm-hmm. So, all right. But is there
Employers need to,
anything?
sorry,
Okay.
go ahead, sorry.
So, and I was just going to ask, is there any way they can avoid these, maybe answering to these FDM, politely, of course, maybe saying that I would like to have my attorney while I answer or something
They
like
can
that?
always do that. They can, if there's any legal matters that they don't know that is complicated for them, they can always say, you know what, let's schedule a time where my attorney can be present and explain. I have the documentation, what I can, but if I don't have, maybe I'll keep it ready. I should have, but I didn't, or maybe my attorney has it and I don't. They could definitely,
Okay.
and not that the attorney would be immediately available for them to
Mm-hmm.
show up at their physical location, but they can definitely ask for time. So, in order, I would say the best practice for the employer is to make sure your public access files are kept up to date in case of an inspection, maintain employee payroll records, payroll information, train your HR personnel to be prepared for these unannounced FDNS visits,
Visits, yeah.
um, and make sure that your employees know their job roles, their wages, their work site location. Sometimes people get nervous, if they are a programmer and they'll say, I'm a software developer, they're completely giving wrong information. So they need
Right.
to be, addressed properly, and keep your documentation organized with the LCA,
Mhm.
employment agreements, uh, any kind of organized org charts are very important. So employer needs to maintain that.
Right, right.
These are the
So,
ways to avoid uh, intricate FDNS questioning.
Thank you so much, Uma, for bringing them up and highlighting them. So I really hope that people are pretty much ready for all these more site visits, you can say, this year. And also, we were speaking about what can happen to employees, but do you think the same is going to happen to the company also who doesn't follow these FDNS site visit rules? Maybe do you think it'll affect their reputation and even the ability to maybe even hire
It
H-1B
can,
workers for them?
it can, and it can, I mean, once they've had an FDNS visit and they find a lot of violations of the employer, then anytime you file an H1, you can expect RFEs, you can expect NOIDs, which is the notice of intent to deny, or in a situation where they feel they violated, they can always do a notice of intent to revoke that current H1B as well.
All right. Thank you so much, Uma. Now, well, we got Kaylee Huey saying hello. So, hello to Kaylee, Kelly. Sorry if I've got your name wrong. But thank you so much for joining us. And if you have any questions, do ask or join us on call. You can dial this number 425-436-6335, and the access code is 988-888. So, especially folks out there whose questions we address, don't forget to also like our channel, subscribe to our channel, and our handle is at Immigration Talk Show. Follow us, connect with us. We are not just on YouTube, but also on LinkedIn, Facebook, X, Instagram, and stay connected with us. Watch out our space because we have so much information all the time coming up, the latest ones, updates that you don't want to miss, and also so nice to have Attorney Uma Mantravadi today, from the Mantra Law offices. So thank you so much, Uma. Now, I have another question. And, if an IT company faced an FDNS site visit in February
Mhm.
2025, shortly
Mhm.
after the new H-1B compliance regulations took effect,
Sure.
unprepared and unable to provide the required documentation or personnel, the company was flagged for non-compliance, and this led to several H-1B petitions being denied or revoked, severely impacting operations as well. So, following this, the company implemented strict compliance protocols to avoid future issues. So, how can companies ensure, especially immediate access to necessary documentation during site visits?
First thing I tell employers, please have an attorney who can help you with your public access files. Make sure your I-9 is in compliance. Make sure you're an e-verified company. There are many things you can do to avoid even being red flagged and having a site visit. As I mentioned, as long as there is no fraud or violations, everything should go well. But first thing is to contact an attorney. There are attorneys who also specialize, particularly in public access files, how to maintain, what do you have to do, what are the documents that are required, how do you be ready for an FDNS site visit. So there are attorneys who do that, and I do assist my employers who are working with me to make sure that they have a complete and proper FDNS visit public access file so that they don't have too many problems.
That's a really very kind of you and thoughtful of you, Uma. So um, I think it's always best to have an attorney by your side and lead you and guide you in the right path. So why not contact Attorney Uma Mantravadi, and you can do so, by asking for more attention on your case by dialing this number 713-787-5297. And you can also email Uma about your case to uma@mantralaw.com. You can note it down, it's there on the screen below. And also go visit www.mantralaw.com to get to know more about Attorney Uma Mantravadi. But for now, I would say stay with us. We'll just go for a short break and we'll be right back with Attorney Uma Mantravadi on Immigration Talk Show. Hello, everyone, and welcome back to Immigration Talk Show. So, this would be the second part of the webinar today. We are having with none other than Attorney Uma Mantravadi from Mantra Law Office, Texas. And it's very nice to have you, Uma. It's such a pleasure always, you know, to have your expertise, your knowledge, you imparting that with us in our show. So, thank you. And
Most welcome.
And also, it's really lovely, folks, that you join us with your questions. So I would really like to quickly take up this next one. This is from Mohammed, and he's asking, what are the new regulations? We
New
already
regulations
addressed that a
about
little time.
what? I think we've already discussed it over and over again. So,
Yeah.
all I can tell Mr. Forget his name, Mr. Muhammad.
So here.
Uh-huh. Mr. Muhammad, you can go to the USCIS website and go to H-1B modernization rule, and it's all there. You can look at it if that's what you're looking at. I don't know, it's a generic question about new regulations. So if it's about H1, you can go there and look up the new regulation.
Yes, in fact, if it's about H-1B, we already discussed a little while back on this very episode. So you can always stream this episode again once, I mean, watch this episode again after the stream is over as well. So thank you, Mohammed, for your question. And now we have our next one. This is from RK. Oh, Kaylee asking, I currently live in Ethiopia and trying to take USMLE. I am a medical doctor. What will be the next step after my USMLE?
I wouldn't know that. That's something you'll have to check in the medical field whether you need to go do additional education, residency, board exams. I'm not familiar with that. That's something you'll have to check it out.
Okay.
I don't know
Well,
what step, because all I know is USMLE is got a step one, step two, step three, and then you have to match to the residency programs. And if you do get into the residency, that's what you do. But I don't know more details than that. It's only a general information.
thank you. And thank you, Kelly, for your question. Now, let's take up this next one. This is from RK. If a site is done and the employer is found to not be in compliance for one or two employees, what happens to the other employees at the same employer?
Possibly even they can be, their cases can be questioned because there was a red flag on this employer. So there is
Mhm.
a possibility that, you know, once a doubt, they can, you know, go into other cases too.
Okay.
Possibly. We don't know that.
All right. So I also have another question which I received in my WhatsApp. But before that, Kelly is already saying, okay, thank you. Thank you again to you too, Kelly. And this next question I received in my WhatsApp is I'm Abraham. I get your contact from the internet. Thank you so much for joining us. I am from Ethiopia. I need to go abroad, work hardly, and help others. So, my question is, how can I get H-1B visa? Could you help me, please?
Well, right now the H-1B lottery is going on, and if you have an employer who's willing to file your H-1, you can file your H-1B electronic registration, and if you're lucky, you get picked in the lottery, then you go forward. And the deadline for filing is March 24th, 2025. So make sure your employer files your registration, electronic registration, before that date.
All right. Thank you so much. And thank you, Uma, for taking that up. All the best. I know it's a very vast question, but I really do hope that you qualify and have a job waiting for you. So, all the best to Abraham. All right, now next question to you, Uma. Let's get back to our questions. Okay, let's take these from our Facebook groups, or this is from our YouTube channel. And this is, if I petition from August 2017, got welcome letter and numbers from a couple months now, but the payment is not opening for me to pay. It's for my over 21 children in Jamaica. Now, this
I
is
didn't
interesting.
understand the question.
If I petition from August 2017, got welcome letter. I think
Welcome
his,
letter meaning they got a green card welcome letter.
yes, probably their
Is
dates are,
that what I can assume?
yeah. So maybe, so a couple of months of petition for child over 21 years. Okay, could be that too. But for a couple of months now, he's received this petition, but the payment is not going through.
I don't know
Uh,
what payment they're referring to. Is that the NBC payment? You would have already done it if you've already got the green card approval. You're saying you've got the approval, but then you're talking about the payment. So it's confusing. I would suggest whoever this is, please reach out to me individually, and I'll be glad to take it up and then, answer your question. Please send me
yes.
an email to my email address, uma at
Certainly.
mantralaw.com.
Thank you, Hermione, for your question, and do message Uma. Now, this one is from an anonymous participant in Facebook, Uma. So they're asking, "Hey everyone, I was rejected twice for my F1 visa interview 3 years ago when I applied for my bachelor's. Now I'm planning to apply again for my master's in the United States, and I want to make sure I address any political issues and strengthen my application this time. What factors should I be careful about, and does anyone have insights or advice on improving my chances?"
Uh, all I can say is I don't know what happened in the past. So I would have to look at the past history, why he or she was denied twice in order to make sure they strengthen their case this time. And a lot of
Right.
times, what happens if you've had a denial in the past, few people keep getting denials, and few are lucky enough to overcome those denials and get a visa approved, be it a B1, B2, F1, H1, it doesn't matter. But we have to look at the history to determine what went wrong there in order to correct it now. So,
Right.
again, if you want to reach out to me, you're more than welcome to.
Right. Thank you so much, Uma, for taking that up. And anonymous participant, you can always reach out to attorney Uma Mantravadi at uma@mantralaw.com. And you may even call her on this number, 713-787-5297. So let's go on to our next one. This next one is a typical situation. I'm on H1 and recently moved to US. Since my wife can't work on H4, I'm thinking of applying F1 to get her to the US. Please suggest, what if they ask why F1 instead of H4 in the visa interview?
Well, my advice would be, or my suggestion would be, let her come here on an H4, and then you can always change it to an F1 when she's in the US to avoid any issues.
Absolutely. Thank you, Uma, for that very direct and prompt answer to this typical situation. And this next question is, "Hello, everyone. I have a query regarding H1 transfer. The current employer, they see where I'm working, filed H1 transfer in normal process on January 15. At that time, I got another offering from a big tech company, but they were doing background verification and now they completed and processing my transfer premium. So the attorney is asking latest pay stubs, but my employer is saying that they have a payment period of 45 days. So I will get my salary on the 15th of March. I joined on receipt notice as my grace period was about to be over in a few days. Initial document I gave to attorney was my previous employer because that time I was in grace period. Now what should I share with the attorney?
This
Thanks.
is way too much information. I'll have to, speak to this person individually,
Mm,
Nipasa, because I'll have to get a lot more information before I can give them any kind of guidance. So I would advise them to reach out to me, and then, we can take it up, because there's a
absolutely.
lot more information that I need other than what they are saying here.
Right, right. So, anonymous participant, do reach out to attorney Uma Mantravadi, and her contact details are already on the screen. I hope you have noted it down. Let's go on to our next one now. This next question are okay. We have addressed all our Facebook and YouTube questions for now, but also another question I have for you is, Uma, if you can tell us,
Sure.
how to follow FDNS site visit rules affect H-1B employees' ability to work and stay in the US, which
Sorry, would you repeat that question?
how could failing to follow FDNS site visits, the site visit rules, they affect these H-1B employees' ability to work and stay in the US if it's an
Well, if the
H-1B?
employer doesn't comply with the FDNS site visits, during the FDNS site visits, As I said, they can get a notice of intent to revoke or a notice of intent to deny. And would that be all the cases possible or some cases? We don't know. So they need to, first of all, during or prior to the FDNS visit, an employer is required to cooperate fully with the FDNS site visit to demonstrate their compliance with the H-1B regulation. So, in order to do that, they need a point of contact, somebody who knows all about the company, the H1s, like an HR or an immigration attorney to handle site visits. And they need to make sure that all the essential documents are there in the public access files, including pay records, work schedules, everything. So they need to make sure they are in
Mhm.
compliance, or at least make sure they're ready for the compliance.
Mhm.
Speak to an attorney. FTNS visits can be very, very damaging to an employer if they don't maintain proper documents.
Right. So, and anyway, like it's very important to have your documents right, and uh, there are documents that you should also keep with yourself at all times: identity card, of course, and your visa status, with no doubt, and also your passport, maybe, because you may be asked anytime.
Absolutely. That's for the employee, keeping a copy of the I-797 approval, copy of your passport, your current driver's license. All of that is, yes, a requirement. But for the employer, the FTNS site visits are more stringent on the employer.
Right. Right. Thank you so much, Uma, for that. And maybe, before we wrap up, are there any points or end notes that you would like to make, especially with regard to our topic of discussion today, that is the April visa bulletin, and what is the impact of new H-1B regulations and FDNS site visits? Anything more you want to add before we leave?
Sure. I always like to tell people this, especially now under the Trump administration, the second term. Don't take chances. Please, contact an attorney. Ensure that you're in compliance with all the, whether it's an H-1B regulation, L1, TN, E2, E3, F1, doesn't matter. And second thing I would advise is this is not a time to travel. Do not travel. Avoid it. Just stay put. Because if you have issues, when you come back at the port of entry, CBP is not being very kind on people. They're even deporting permanent residents. So I wouldn't take a chance.
It's
Do
crazy,
not
but
travel if it's not necessary.
thank you so much, Uma, for those very important points and advices. So, with that, I think we have come to the end of our episode today. This very important webinar, full of important updates and a lot of discussion, a lot of important points to keep in mind as well. So, I would say thank you so much, Uma. It's always a pleasure and an honor to have you here
My
with us.
pleasure. Have a good
No,
one and a
you
wonderful rest of the week.
You too, Uma. All the best. And friends out there, thank you so much for joining us once again. And if you want to have a one on one consultation with attorney Uma Mantravadi or contact her, do call her on her number 713-787-5297, or email uma@mantralaw.com, and go visit www.mantralaw.com. Also, you can email me or WhatsApp me in this number. My number is 408-335-6444, and my email address is nipa@staffingly.com. But before you leave, friends, don't forget to subscribe to us if you haven't as yet already, and do like and share. Also, don't forget to hit that bell icon and get notified whenever we have discussions like these. And that said, thank you once again for joining us on Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, Instagram. Check us out, connect with us, and watch out our space because we have a lot of important updates you don't want to miss. Bye for now. This is Nipasa signing off.